Welcome everybody. My name is Eleni Costa. I'm a professor of technology and human rights at the Tilburg Institute for Law, Technology and Society of Tilburg University. And I would like to welcome you to this panel on the use of AI in state surveillance, challenges for privacy. Obviously, we're going to talk about artificial intelligence and surveillance, as the title reveals. Artificial intelligence enhances the surveillance capabilities of law enforcement authorities and security and intelligence agencies. Surveillance drones and live facial recognition programs are recent examples of the increasing use of artificial intelligence by LEAs and SIAs. Examples have been prominent, and probably you have read about these things in the news. The UK Metropolitan Police Services, they trialed live facial recognition technology during some policing operations. Similar facial recognition technology has been used by the Hamburg police in 2017 already during the G20 summit. Same in Berlin and in France, as we will hear from some of our panelists. So the use of artificial intelligence for state surveillance was also discussed this morning during the morning panel, has been challenging human rights protection. Based on parameters that are usually fed by the law enforcement authorities themselves and the security and intelligence agencies, resulting from autonomous algorithmic computations, algorithmic surveillance creates groups of people, often that are seemingly completely unrelated to each other, whose rights need to be protected. We see explicit or implicit biases embedded in machine learning algorithms, which can lead to discrimination. Individuals may not be aware that they have been singled out as matching a suspicious profile or fall under a dynamic algorithmic group. So all these are issues that we are going to touch upon today. So I think we all agree that advancements in artificial intelligence lead to a paradigm shift in the exercise of state surveillance, which actually poses vital challenges on human rights protection. So in this panel, we are going to discuss the challenges that artificial intelligence poses on privacy and other fundamental rights, with a focus on the facilitation and exercise of state surveillance. You have probably noticed, looking at your screen, that unfortunately Zoe Carnacia will not be with us today. So we will be 4 panelists who will give a short presentation, and then we will have a discussion with the audience. You can use the chat function to ask your questions. I have a different screen, so you will see me looking somewhere else, but that is only to check if you have your questions. Without further ado, I would like to give the floor to Professor Theodore Christakis, who is a professor of international and European law at the University Grenoble-Alpes in France. Theodore is the director of Information Security and European Studies, and he's also chairman of the ESIL Interest Group on Peace and Security. Theodore, the floor is yours.
Yes, thank you very much, Eleni, and thanks for organizing this very interesting panel, which will permit to share some of the work we are doing within the chair on AI regulation at the University of Grenoble-Alpes, and I invite all of you to visit our website, ai-regulation.com. And as you said, Eleni, states and security agencies, law enforcement people wish more and more to use AI tools in order for security purposes. This is a kind of silver bullet for them, a kind of holy grail. And the big question is whether this might lead to a big shift of the surveillance paradigm and create a lot of problems in relation with human rights. The fact that security and law enforcement people want to use AI tools can also be demonstrated by the recent white paper on security published by the Ministry of the Interior in France in November last year, where you see a lot of proposals that we discussed in our website but I will not discuss everything because I only have 9 minutes left. I will just focus on the specific issue of facial recognition, and Lotte after me will also continue on this, because we know that there have been a lot of evolutions on this specific issue, which is of a particular importance, taking into consideration the very sensible character of biometric data. And well, it's very interesting because Lotte will tell you about all these NGOs asking for a moratorium, and we have a lot of recent developments, and this campaign, Reclaim Your Face, Lotte will expose to you. It's interesting because somehow there was a small moratorium in the use of facial recognition during the COVID crisis. Well, not really, because I've seen some uses which were created because of the COVID crisis, like checking if people are wearing masks or if they're respecting quarantine, etc. But nonetheless, it is very clear that security and law enforcement people, and I have talked with several among them, are dreaming of using these tools, and some of them are already doing this. There are more and more countries in Europe who are experimenting, let's say, with use of facial recognition in public spaces. If I only focus in France for a minute, this white paper includes a lot of proposals in this respect, and you can also find them presented in our website with 3 phases of experimentation. In France, for instance, security and law enforcement people are dreaming of using facial recognition in things like the World Cup, Rugby World Cup, which will be organized by France, or the Paris Olympic Games, or in other events, or if there are any terrorist attacks. And I hope you can hear me because I heard the voice. And there are proposals, for instance, to use a 3-phase in experiment. First, a black experiment based on voluntary grounds and on consent. Then to pass to a second phase, which would be to deploy the facial recognition technology the highlight is that we have all this trend. We see it also in countries, in Germany, in Italy, in other places. And at the same time, we have the DPAs, the data protection authorities, which are more and more concerned about all these issues. In France, for instance, the French DPA, the CNIL, has been very active in relation with facial recognition issues, and has published very interesting opinions and documents criticizing some uses. And this has been confirmed, by the way, by decisions of French tribunals who have endorsed the position of the CNIL in relation, for instance, with the use of facial recognition in order to enter schools in the south of France. But also CNIL has published very interesting papers concerning this idea of experiments. And there are plenty of interesting things in these opinions of the CNIL, and that I invite you to read, and especially a heavy insistence on the proportionality, the necessity, the proportionality, the proof that there are no less intrusive means for a specific legitimate purpose, and a lot of caution for live facial recognition, saying that this requires a thorough analysis. You all know, unfortunately, I only have 5 minutes. I wanted to discuss, we are working a lot in the AI regulation chair on several issues, and we will publish some studies in the coming weeks and months. But one of the issues that we're discussing a lot is the Bridges decision. You know, this very important decision, the Court of Court of Appeals published this decision back in August. Somehow the NGOs were happy because they won on several issues, because the court found that the use of facial recognition, live facial recognition by South Wales Police in England, in the UK was illegal. Why? Because of the problem of the legal basis for the processing. There were not enough information about how you constitute, for instance, the watch lists, or failures in doing a data privacy impact assessment, or the court emphasized the duty that authorities have a duty to check the non-discrimination principle. This is a positive obligation. And all this needs a lot of concerns of NGOs and civil society concerning accuracy, concerning bias, concerning the legal basis. All these are important, but all these things can be addressed in a way or another. And it's interesting, for instance, we have also published recently a summary of the proposals of the Surveillance Camera Commissioner in UK, who precisely proposes specific measures in order to address all these things that the court said in the Bridges case. But our main concern is the fourth point in relation with the Bridges decision, the issue of proportionality. And it's very weird that nobody discussed this issue in a thorough way. The court said on this issue of proportionality that everything was okay, while in reality, this is for us the major issue that should be discussed and addressed. And of course, there was they didn't bring the case to the European Court of Human Rights, for instance, because they won the case on the other grounds. But the real issue for the future of the use of facial recognition, let's imagine that facial recognition becomes extremely accurate, there's no bias, is this a reason to use it nonetheless? And the court said that I would like to have your reactions of the other panelists. The court said that it's okay for proportionality because the interference with Mr. Bridges, who was passing, and his biometric data have been captured by the cameras, was very limited. Why? Because the interference was only limited to the near instantaneous algorithmic processing. No personal information relating to the claimant would have been available to any police officer or to any human taser. No data have been retained. There was no attempt to identify the claimant. We erased everything, and everything is okay. And the court said, of course, we do this with all the people who cross the road. But the court said that we cannot add all these small interferences in all these people. The court said that an impact that has very little weight cannot become weighted simply because other people were also affected. It is not a question of simple multiplication, said the court. And there was no debate about it. And I'm very surprised because, as a matter of fact, the whole issue about the use of facial recognition and the thing that we find on all the DPA's approaches is precisely that. First of all, the fear of creating a chilling effect on people's fundamental rights and freedoms. What would be the societal impact of the use of this kind of tools? And the fact that there can be function creep, that we all know how it works, that as soon as you try to deploy tools like these, intrusive tools for facial recognition for a specific purpose, then you use it for other purposes. We just need the next crisis in order to see the function creep, a terrorist attack, and then we will start using all these tools in a more massive way. The next pandemic, we have already seen this during the pandemic, that we're using cameras in order to see if people were wearing their masks, etc., or respecting quarantine. The next massive riots, and then we will use these tools, and they will be more readily accepted by the different persons. And I just want to end here, as I see that my time is running over. It's very interesting because this function creep is something that is constantly present in the publications of all these data protection authorities. We are studying all the positions of the data protection authorities within the chair. It's very interesting to see the position of the CNIL on this, but also the German Federal Commissioner for Data Protection, who published a few months ago, it was just 1 month before Bridges, by the way, he said that contrary to the court that said that it's an insignificant, very limited interference, he says in his report that facial recognition represents a significant incursion into the individual's fundamental rights. What a contrast. And he also says that What is more, experience has shown that the legal restrictions on access to data that are initially imposed are gradually scrapped over time. If the legislator allows the police to use biometric facial recognition, there is a very real risk that the opportunities for surveilling the public using biometric characteristics will be expanded step by step, a development that cuts to the very core of our coexistence within society. And he concludes, I recommend that video surveillance with biometric facial recognition should not be used in public spaces. So these are the things that we do understand. I conclude, Ellen, we do understand the position of the security and law enforcement people in relation with there are other uses which are probably less concerning, but we're talking here about live facial recognition and surveillance. We do understand that they want to use all the tools available in order to protect societies. On the other hand, there are a lot of concerns which are often expressed, including the concern of action creep and this chilling effect of surveilling everybody, and there is a real need for societal debate and take all these considerations very seriously. Thank you very much.
Thank you very much, Theodore, for this very rich intervention. I have to admit that I had at points some difficulty understanding everything due to the connection. I hope the audience did not have similar problems. So I would like us to move to the next panelist. Our next panelist is Lotte Houving. She's a policy advisor and researcher at Bits of Freedom, which is a Dutch digital rights organization here in the Netherlands. And Lotte will tell us a bit more on facial recognition and the Reclaim Your Face campaign. Lotte, please.
Thank you, Ellen, for the invitation and the introduction. I feel very honored to be part of such a panel full of expertise. And I remember last year's CPDP, which I very much enjoyed, by the way, and how much sessions there were about facial recognition, the hot topic of 2020 CPDP. One of the questions I raised in my introduction on the panel about facial recognition that year was a rhetorical one. Do we think it is acceptable to be reduced to walking barcodes? One of the people I met at last year's CPDP is Bogomir Doringer, and he inspired me by talking about surveillance in terms of decoration and technology that is choreographing us, leading to the question, what kind of society do we want to live in? And acknowledging that technology is influencing our behavior and our society, where do we draw red lines? Last year, this question was already rhetorical. Of course, we did not think it was acceptable to be reduced to walking barcodes, and we were drawing red lines at face surveillance in public spaces. However, we also knew that the problem was not limited to the surveillance of our face. Banning just facial recognition would not protect us from the reduction to walking barcodes, and it would not protect the vital role publicly accessible spaces play in a democracy. This is what brought us, 12 European digital rights groups from across the EDRI network, to launch the Reclaim Your Face campaign and pled for a European ban on surveillance technologies, biometric surveillance technologies in publicly accessible spaces. We do this because we are worried and we want to signal a problem. There seems to be a trend to automate surveillance. This process of automation brings along several risks. We see problems with the use of predictive policing, where sensitive demographic aspects and socioeconomic data like sex, amount of non-Western immigrants, and amount of people that are receiving benefits are used to make inferences about the risk of crime in certain neighborhoods. And where this data, combined with historical crime data, is creating feedback loops and exacerbates existing prejudice and inequalities in our societies. This is not only the case with predictive policing. An aspect we see in all surveillance technology that works with some kind of profiling is that the profile is based upon a certain image of what the surveillant is looking for. This image can be built up from human impression or from data. The latter may sound more objective, but we should not forget that this data is subjective and established in colonial and patriarchal structures. When people put their bias into technology, and this technology is used to single people out, this automation process does not make it more objective, but more efficient, and therefore even more dangerous to our societies when we want to build them on equality and non-discrimination. We should be very careful with what kind of technology we hang in our publicly accessible spaces, since this technology is shaping our behavior. Think of fast lanes for easy access if you choose for the entrance with facial recognition at, for example, a stadium, but also of cameras detecting unusual or suspicious behavior. What is unusual? It is interesting to note that in a risk society, the difference between unusual and suspicious seems to get smaller and smaller. Will this normative influence of technology stop us from dancing in the street if we feel like it? Or what will happen if we do? Is this flagged as divergent and therefore maybe suspicious walking pattern? And what will have this in terms of effects? Surveillance technologies analyzing our bodies and behavior as we go along are reducing us to walking barcodes, ready to be scanned and linked to information in existing and searchable databases. They are changing our behavior as we either nudge to use them in the quicker queues or influenced by them by advertisement that is shown us to be based on our perceived and quantified emotions. They are changing our society as values like security and order are presented as the uncontested holy grail of a functioning democracy. They're also changing the way the rule of law is functioning. When crimes are predicted, the moment of intervention and deployment of capabilities is before we can speak of a reasonable suspicion. When biometric surveillance technology is used in publicly accessible spaces, the biometric data of every random passerby is processed and checked with a list of specific persons. This means that everybody is treated like a suspect. We should choose wisely what technologies we allow to influence and shape the societies we live in. The Reclaim Your Face campaign draws a clear red line at biometric surveillance in publicly accessible spaces. To protect ourselves, our rights and freedoms, and our democracies, we launch an ECI to call for the Commission to take a stance and ban this biometric mass surveillance. Thank you.
Thank you very much, Otto. That was very clear, and the final message was indeed very clear. So we are waiting to see what the Commission, how the Commission will respond to the calls you and other civil rights organizations are making. So now I would like to give the floor to Plixavra Voyagoglu, who is a doctoral researcher at the Center for IT and IP Law at the KU Leuven, and she will give us her insights on AI and predictive policing.
Yeah, good afternoon from my side as well. And thank you, first of all, Eleni and the organizers for the opportunity to participate in this panel on the use of AI for state surveillance. As Eleni mentioned, I'm a doctoral student. I'm researching on the justifiability of interferences with fundamental rights caused by bulk transfers of data from private to public sector actors for the purpose of crime prevention. And today I will focus my talk on the use of predictive policing by law enforcement and intelligence services. First, I want to briefly explain what it is that we refer to as predictive policing and what are the potential uses. Then I will present some of the challenges they pose for fundamental rights, for privacy and other fundamental rights, specifically in cases where data not originally linked to a crime are used. And finally, I will comment on some case law that's relevant for the mitigation of these risks. So starting with what is predictive policing, it is commonly defined as the application of analytical techniques to identify likely targets, whether that is individuals or geographical locations or circumstances, in order for security actors to intervene and deter criminal offenses from being committed. These algorithmic tools rely on theories of criminal behavior and the so-called near repeat effect, according to which crime and criminals tend to follow certain patterns, making it possible with a certain degree of reliability to predict where, when, by whom, or to whom certain types of crimes tend to take place. Currently, the use of such technologies is still relatively limited, although there are recent reports, like the Automating Society of 2020 from Algorithmic Watch, that show how several European states, like Germany, Netherlands, Italy, Spain, and others, have started to adopt different predictive policing software. So predictive policing is here used as a catch-all term that encompasses different AI systems, that are used to assess risk of harm and aid security actors in their strategic planning and intervention. Therefore, the sources of data used by these technologies vary. It can be analyzing historical criminal records in order to define criminal hotspots. A common example is burglaries. But it can also be the processing of large amounts of diverse personal information to look for patterns, create criminal profiles, and identify individuals considered suspicious. For instance, in the context of counterterrorism and fight against crime, predictive policing may rely not only on past criminal data, but also on data generated in the context of commercial activities held by private sector. Common examples include financial data, air travel information, and telecommunication services non-content data, also known as metadata. Banks, for instance, have started to adopt predictive policing technologies in order to identify transactions that are considered suspicious for money laundering or terrorist financing, which they then have to report to specialized security units. Similarly, air traffic carriers transfer all the PNR data that they collect, that is data required to book a flight, to specialized security units, the passenger information units, for the purpose of preventing terrorism and serious crime. Then these specialized units process the PNR data to carry out profiling assessments to identify the suspicious individuals, but also to update the criteria for these profiling assessments. So the same data are used both to employ the predictive policing technologies, but also to further develop them. And another example concerns metadata that are generated and collected by telecom companies that are retained and further accessed by security actors for national and public security purposes. So these national schemes of data retention and access seek to facilitate the identification of past crimes, but also to enhance the intelligence gathering capabilities of the security sector to prevent future crime. However, both the data sharing frameworks and predictive policing technologies bear distinct risks and challenges to fundamental rights, and when combined, these are even more accentuated. On the one hand, the provision of bulk amounts of data from the private sector is often referred to as mass surveillance because it affects numbers of innocent individuals in order to look for the few threatening ones. And on the other hand, predictive policing technologies, as Lotte also mentioned earlier, and as has been increasingly reported, raise numerous questions, both regarding its efficiency and true capacity to deliver what it promises, and with regards to interferences with fundamental rights, namely privacy, data protection, but also presumption of innocence, freedom of expression, and equality and non-discrimination. So now, focusing on the application of predictive policing technology on personal data that are not originally linked to crime, there are further questions on how to assess data protection principles like data minimization, purpose limitation, and as well as the overarching necessity and proportionality. So as I mentioned, methods of predictive policing rely on the probabilistic processing of personal data in order to look for valuable patterns. To be able to do so, the raw material must consist of the right quantity and quality of data. How then to define which quality and quantity of data, and in this case data that's not originally linked to crime, is right and necessary for predictive policing technologies to function optimally and deliver efficient results? It can be said that more data will allow for more useful and reliable patterns in order to make predictive policing more effective. In this regard, there has been some case law from the Court of Justice that is relevant in this discussion. Take the example of the PNR data processing. According to the directive, the data of all passengers has to be collected and transferred to the specialized security units. And that is justifiable according to the court because the security actors are looking to identify risks that are yet unknown to them. This seems to confirm that in the context of prevention, when we're looking for unknown risks, more data is better. The court has also provided for several criteria to ensure the necessity and proportionality of the reprocessing of telecommunications metadata for the prevention of crime. You know, the Tele2 Watson and recently Locatretur.net, very long cases, and amongst other, both the retention, according to the court, both the retention and the access to data by security actors have to be based on objective evidence, making it possible to identify persons whose data are likely to reveal a link to a crime or can contribute in one way or another to the prevention of crime. But what is objective evidence of contribution to the fight against crime when predictive policing technologies are employed? Well, of course, the answer will also depend and be assessed on a case-by-case basis, depending on the specific software and depending on the specific crime, whether that is terrorism or some type of serious crime. The guideline of objective evidence of contribution to the prevention of crime is rather dubious. How to implement objective criteria and define the quality and quantity of data not originally linked to crime that is capable of contributing to the prevention of crime through predictive policing technologies, especially when security actors are employing these technologies precisely on the grounds that they are looking for the unknown. Objective evidence of contribution to crime may therefore be interpreted as what the technology needs to function optimally. As the use of larger databases arguably allows for better detection of patterns that would otherwise have been missed, contribution may be achieved with more rather than less data. And in this way, even though the requirements set by the court may be formally set to be fulfilled, the effect on fundamental rights is the opposite, as the requirement is interpreted rather broadly, widening the scope of persons, innocent persons affected. In light of all this, I would like to conclude my talk with a call for special attention on the use of predictive policing technologies in state surveillance. Besides the broader concerns on the deployability of predictive policing, it's important to look at its specific use, and in this case, whether data not originally linked to crime should be used for such technologies. First, it's imperative to understand how the technology works, what is the minimum quality and quantity of data that they require to function effectively. Second, it's important to clearly define what it means to have objective evidence of contribution to the prevention of crime, especially in the context of predictive policing. And finally, we need to consider if the outcome is the appropriate, least intrusive solution that provides for a fair balancing between security and fundamental rights. Thank you very much for the attention.
Thank you very much, Sabra. That was indeed very detailed and very interesting, and it gives a different aspect compared to what the other two speakers have presented us. So last but definitely not least, we have Christian Stenberg. Christian is the Chief Privacy Officer and the DPO of the Danish Police. He's also the DPO of the Danish Passenger Information Unit that was established in Northern. And at this moment, I would like to welcome the audience to ask questions through the special field on the right hand side of your page so that we can
Thank you so much, and thank you for having me. I wanted to lead off with some general remarks, and then actually also pick up on some of the very poignant remarks made by both Theo and Plixvama. As a general point, I think I wanted to speak a little bit about AI, also maybe from a different angle, talking about AI and national security, surveillance, and law enforcement. I think it's important to note that there's also from a data protection side, a positive angle, which is that because just like on the front end, you could say that the police and law enforcement are dealing with very large amounts of data. The same is also the case on the back end of our IT system. So caring about data protection, you need to care about how data is actually processed internally in law enforcement agencies. And one of the practical issues you run into in the modern day is that there is a lot of data on the back end, records, logs that need to be audited, and that is practically impossible. It is basically impossible to do on a human level. you need IT, you need technology to assist you in order to carry out an efficient auditing of the compliance checks that you want to carry out on how systems are used. So I definitely, in the coming years, hope to see on the back end also the application of something like AI in order to enhance our ability to see how data is actually being used, both in the sense of, is anyone accessing that data unwarrantedly? Is someone misusing their access to police databases? That is a risk we are, of course, very aware of, but also to gain better insight. I think, as has been already demonstrated in previous panels here today, or the former panel on data retention, there is this continuous sort of questioning on many different areas in the crossfield between law enforcement and data protection of, is this really necessary? Can you even document that this adds value? And this has been a tortured point, I must say personally, in regards to data retention for many years. It's still being stated today. Do you even use it? Is it even valuable? It clearly is. Let there be no doubt whatsoever. And we have documented that, including before the court in the recent cases. So that is a mute point for sure. So if anyone wants documentation, just give me a call. But also, we want, when we deploy new technologies, that could be everything from license plate readers to PNR, the better ability we have to oversee what we're doing with data on the back end. What is the actual value? How often is something accessed? That will speak to what kind of retention periods do we actually need? How many people are actually using this database? That will speak to how many users should we allow to access this specific data set. Those types of questions would be so much easier to ask and to get answered if you could deploy and will deploy AI in the future. So I think that's an important from a standpoint of data protection and the broader discussion and debate we have both on a legal and a policy level. That would be really interesting to have better AI. Hopefully we will get that. We are working on it in the Danish police, only on a large, very small scale, but hopefully going forward that will be part of the debate. And then just to touch upon something that's already been mentioned today, facial recognition, which Theo mentioned. He said at least twice that law enforcement and national security agencies are dreaming of using facial recognition. I think that is definitely true to a certain extent, but I can also state that we are also some members in law enforcement that fully recognizes that this technology has limitations. So I think it's important to remain aware of what are the different levels and types of facial recognition, because I think when you just say facial recognition, most people immediately think of live facial recognition technology deployed in the open spaces, in public areas, scanning the faces of anyone that passes, matching them again. That is clearly the most intensive version of facial recognition. But in practice, I think all of us has been subject to facial recognition if we've traveled within Europe. If you go through the e-gates in the airport, you are basically benefiting from facial recognition technology, where the high quality photo that is in your passport is scanned and matched against a facial recognition image taken at that moment while you're waiting to pass through the gate. And if those two match, then all data is deleted, but we have a biometrically based perfect identification that you are actually the holder of that passport. So that is the sort of, I would say, very low risk, well regulated, based on EU law, use of facial recognition technology that really doesn't raise that many issues. The only residual point you could make is that if you pass through that e-gate, then it would be very difficult for you to argue that it wasn't actually you who passed through that e-gate, because everyone will know that it was a biometric scan that took place. While in other situations where maybe your passport is scanned, you can always argue that I wasn't really there. It was stolen. It wasn't me at that location or crossing that border. So that's probably the real substantive addition or risk, if you will, that type of facial recognition entails. Then you have another, I think, very important use case, which is something that we deploy in the Danish police, something that is deployed also by private sector companies when they assist law enforcement, which is the scanning for scanning of images. And in practice, we will use facial recognition technology, which is basically the same technology that you use to scan for anything else in an image, to look for victims, for instance, of sexual abuse of children. So imagine we have very large databases shared between law enforcement agencies of illicit materials that so material that actually shows abuse of children, that may contain faces of victims or of perpetrators, and having the ability to scan that material in a silo and ascertain whether or not the same victim is part of more or one set of images will actually be an important tool in solving those cases. Because if you can end up connecting more cases, you may also get a better understanding of where is this abuse taking place. Is there a victim out there that is currently being abused that we have yet to identify, but we can use this technology to do that? I think that is a very good use case. And then finally, of course, you have the most extreme example, as I mentioned initially, of the actual live public space use of facial recognition. And I must say, I fully share Theo's point in regards to this court decision that he referenced, where the court basically said you can. It's not a matter of multiplication. I think that disregards the real risk associated, because in my view, if you are actually assuming that facial recognition technology works perfectly, that's still a big assumption, and there are certain technical and practical issues tied to that. But assuming that that is the case, the parallel, because this is biometric information, is basically that the public authorities are taking the fingerprint of everyone walking the street, combining that with their geolocation, and they have no idea that this is taking place. So unlike what we would normally in law enforcement term as an interference of someone's integrity, which requires a legal basis, their fingerprinting, at least they know that they are being fingerprinted. They know the reasons why, and there are there are requirements in procedural law saying you must be charged as a suspect of a certain criminal offense of a certain gravity before that can be carried out. So just disregarding that is basically, if the technology works, the same scenario, I think is unfortunate for a court, and surely from a data protection standpoint, that is not correct. And then finally, just in closing, I just want to say, I think also in using the term predictive policing, I think it's also important, based on my experience, to be very clear what we're talking about. So in my view, something like PNR and something like anti-money laundering monitoring, as Prabhakar was mentioning, is not in and of itself something I would term as predictive policing. I would distinguish in practice between profiling, which is as described, is definitely something that is part of the PNR setup as established by the EU directive. But a profile is in many ways completely traditional police work. That is basically caring about what will someone who is likely to be a perpetrator look like based on relatively objective characteristics. And in the PNR setting, it is very, very difficult to end up with something that is discriminatory. And I would also not term it as prediction, because you're not predicting crime. You are profiling individuals that you may want to take aside for specific screening. Maybe because you suspect that they be involved in crime, maybe because you suspect they might be victims of crime. But in my view, that is not predicting crime. That is singling out based on a recent and continuous assessment of the relevant criteria who you want to talk to. Police has always been doing that. Prediction is, in my view, where you are trying to reach a conclusion regarding an individual and grading the likelihood that they will commit a crime. That is the most intensive version of predictive policing. On top of that, you have information that is used to maybe indicate in which areas or which groups that may be at risk of committing crime or suspected of committing crime, and then at the very highest level of predictive policing, a very traditional version, what we would term forecasting, because it is basically similar to a weather forecast, is just using statistics on reported crime that you already have, and then using that to inform your decisions on where to send patrol cars, etc. But that is, in my view, a not really intrusive at all version of predictive policing. I will end my comments here and hope for some good questions.
Yeah, thank you very much, Christian. There are several questions by the audience, so I will be approving them one by one. I will start with the one that is actually addressed to Christian, so that you can immediately react to that. So the question, I guess you can see, can you see the question?
No, I can't see anything. Can you just read it out?
Yeah, that's the thing. I approved it, and I'm sorry about that. I'm not sure where it went. Maybe somebody can help me.
Probably the audience can see it. Huh?
So here it is. It takes a bit of time to load. So could you, Christian, expand on how sexual abuse situations and image scanning actually works?
Yes, of course. Well, in the scenario that we have deployed in the Danish police is that, as I mentioned, there are based on specific investigations where you uncover abuse of children and the exchange and sale or trade of images of sexual abuse of children. You obviously seize the relevant material, then you deploy hashing technologies, or in this case, facial recognition technology on that material in order to, in the future, very easily scan, for instance, a computer that you seize as part of an investigation. Does it contain the same images? So it's a very efficient way of quickly going through large amounts of data to see, is there already identified illicit materials in this computer? The same pictures we could then deploy AI or facial recognition technology upon in order to, as I said, connect the dots between different parts of or different sets of images. So let's say the same victim has been abused over a long period of time, and there are different batches of photos showing the abuse. Well, maybe in one case you've solved the case and you know who the perpetrators are, or you maybe have some part of an understanding of where the perpetrators are. Maybe you know what country they're in, but you don't know their specific location. If you're able to combine all the relevant images with the same perpetrators or victims or locations, you are obviously getting a better insight and advancing the investigation of that specific case, and hopefully uncovering where the victim is so they can be freed.
Thank you very much. There is another question for all panelists. There has rightly been much scrutiny of facial recognition for surveillance. I wonder if there are any lessons to be drawn from such scrutiny for dealing with emotion recognition. Who would like to answer this question about emotion recognition, which is actually very, very, very interesting?
I'm not sure if I understand the question.
It's about Theodore, would you like to answer? It's about tracking the
emotion. Very quickly, I'm not sure that I've heard the question very well, but the issue that was raised was about emotion recognition. And we know that there are huge controversies about this. There were studies that found that the science behind emotion recognition is extremely limited. And the idea that we can simply, detect people who are lying, etc., all these things is extremely controversial. So I think that any kind of data protection authority or person working on this would advise for the highest caution, especially if this kind of stuff is used in order to eventually have results for people's lives, both in the public sector of surveillance, but also in the private sector.
Thank you. Thank you very much, Theodore. Indeed, I think it is very much related to data protection issues. There is another question. What are your thoughts whether particular applications of AI surveillance systems in law enforcement, for example, FRT or predictive policing, should be banned or put under a moratorium in the European Union? Who would like to take the floor? Not very intuitive. Yes, please, please feel free.
Thank you. Well, I think on facial recognition, in principle, on a personal level, not speaking for law enforcement at all, I have great sympathy for the idea of a ban. I just don't believe it to be practical, enforceable. It will just mean that it will be used, but no one will know about it. To a large extent, probably not by public authorities. We would definitely refrain from using something that is banned for sure. I guarantee that. But I think it will just mean that private sector companies will not refrain from using it. It will just be used in another jurisdiction, but on personal data that is still relevant for Europeans. So I think it's a nice idea, but I'm afraid that it's not practical. But if it's practical, I would support doing it. I do recognize that it is something that should be highly regulated and limited in use. Predictive policing, I think that needs to start off with the initial point I made, that what is it? Define it first before you can ban it. I think we can define facial recognition. Predictive policing very quickly collides with something that is just normal policing. It depends on what specific scenario you're talking about. And I would probably more view it as realistic to see that there are requirements, existing data protection requirements, but also technical requirements, standards that needs to be documented and in place before you can do anything that singles out individual. I think that is the important distinction. Are you doing prediction on a general level, certain areas or certain types of crime, or are you trying to, and that's probably the most common assumption, identify individuals that are likely to commit crime, and that is extremely difficult to do. Anyone I've talked to in law enforcement in the US, which are the ones that are most advanced, I have never heard anyone actually say that this stuff actually works in a way that is a help or is legally sound. So I would be cautious in assuming that that's a very big problem that requires a ban. And how do you even define it?
Thank you very much. So there are many questions, so I hope we can go through all of them in the time we have left. And another question has to do with impact assessments. So what are the views of panelists on human rights impact assessments or algorithmic impact assessments as tools to prevent some of the challenges for privacy that are discussed in this panel?
Well, I think it's, on the one hand, it's a necessity, because before we deploy any such technologies, we should be really careful and assess what kind of human rights impact this kind of technology has. At the other hand, it's quite hard to do this balancing act for every specific case and not get into a situation where we end up with strict regulation, in which case we are really afraid that we will not be able to contain the use of such very invasive technologies. So when it comes to biometric surveillance technologies, we think the only option is to put a total ban. And in that case, we don't need to do human rights impact assessments anymore.
Thank you, Lotte. I think, Plixavra, you also had something to add?
Yeah, I was also like to add to the previous question. I agree with Christian, and as I mentioned, indeed, predictive policing is quite an umbrella term, and before we can discuss ban and impact assessments, it's good to every time define what is a specific software we're talking about. But I think that while, as mentioned also with facial recognition, technology is meant to develop, continuously evolve. So what is not right now happening, it could happen in the future. And the fact is that traditional police work, the reason why we are having this conversation now is because all of these new technologies are making a lot more things possible. And they become a lot more advanced and a lot more intrusive. So I do think that especially data protection and human rights impact assessments, but also technological assessments, because oftentimes data protection and privacy alone cannot help find the right balance when perhaps indeed the individual is not yet affected per se, but when we have general profiling, or even when you're defining crime spots for geographic locations and you're only talking statistics and geographic areas, people are still affected in an indirect way. So it's good to see each technology for what they really do and how they function. Thank you.
Thank you. Thank you, Safra.
Eleni, may I also?
Yes, of course. Sorry, I to you.
And the previous question, I'm very sorry for the bad connectivity. I have participated to dozens of workshops during these last months with Zoom and all these tools. There was never a problem, but here I can see nothing, I can hear nothing, you cannot hear me. I don't know what happened with this platform. There are a lot of parasite noises also. But just to address the question, I think, and the previous question, I entirely agree with what Christian also said during his interview. It all depends on the use cases. I mean, the uses of facial recognition, which can be extremely useful either for authentication purposes. This could increase cybersecurity, this could increase security in general, and not being harmful for human rights or with a very limited impact, or even identification purposes. When law enforcement people, for instance, have a photo of a person who committed a crime and they want to compare it to a database, there are a lot of issues raised, but this is the kind of thing that might be addressed for identification purposes. So in relation also to the question of previous impact assessments, of course, we need to identify the use cases. Data previous impact assessments are extremely important, I think. And we see in France, it is thanks to that the CNIL, the Data Protection Authority, was able to identify, for instance, what they wanted to do with high schools in the south of France was not compliant with the data protection and privacy standards. And while in other cases, they were able, for example, in the airports, were able to advise about how to improve the system. It's extremely important, these tools. So I really think that we should not put everything on the same basket. I entirely agree with Christian on this. And we really need to think very carefully about the use cases and adopt appropriate responses for every use case.
Thank you, Theodore. That's indeed a very valid point. There is another question, so I'm trying to filter out things because I would like to definitely go through all the questions about the inadmissibility of bulk data as evidence. Are there any exemplary national court decisions which actually exclude indiscriminately collected data from evidence? If you're aware of any cases, of any national court cases which exclude indiscriminately collected data from evidence? So that would be the question. Theodore, and then click Safra.
Yeah, I will not answer to the whole question, but in relation to facial recognition, recently in France, there was a very interesting case in Lyon where precisely the police used the photo of the person and they compared it. It was the only clue they had in a burglar case. They compared it to a database of persons in a criminal database and were able to identify the person. The lawyer challenged this was not indiscriminate collection, so if it really responds to the question, but it was use of facial recognition in a criminal case, and this has been challenged by the lawyer. And as a matter of fact, the court did not upheld this challenge, saying that this was just one of the elements used by the police, and of course there were investigations that said this was a helpful tool, but this was not the determining tool that permitted to convict this person. I don't know if this helps in relation to this question.
Thank you. Whichever you don't mind, I would like to move to the next questions. Maybe you can, because we have very limited time. So there is a question. Christian said that certain forms of data-driven police profiling can be unintrusive and not harmful. But I think that using data about groups or other in order to predict criminality of a specific individual can really harm the presumption of innocence, due process rights, and other rights such as equality and non-discrimination. How do any of the panelists feel about this? Plixavra, now I think
Well, I think to an extent, I also made the same point earlier that it doesn't have to be that we process one specific person or that we identify a person before they commit a crime, and that only then their rights, their fundamental rights, are being interfered with. All these technologies and the processing of data in order to be able to create profiles and then apply them is already intrusive, and we need to see whether this is really needed depending on its use, technological use.
Thank you. I don't see if any of the other panelists want to react. Yes, Christian, please.
Yeah, I would just caution against making very sweeping assessments or judgments saying that doing profiling, for instance, will lead to material effects on the presumption of innocence, etc. It's important to always recognize that law enforcement, at least within the EU, obviously, is subject to numerous legal standards and requirements, and this all needs to end up in court at some point, and you have many rights if you are being questioned. And I would also say again that the profiling, for instance, that takes place using PNR data is profiling that has always been carried out. Back in the day, 20, 30 years ago, where there were border controls everywhere, including within the EU. When you walk into another country, you had to show your passport. You had to verify who you were. You need to probably answer questions. You need to declare things in customs. And you could be pulled aside for questioning, based pretty much on a very personal assessment by an individual officer, making it somewhat arbitrary and not necessarily transparent in any way. In light of the way the EU has evolved, where borders are now open to a large extent, and when external and internal borders, we use PNR as a substitute for that. To say that because the majority will not be stopped, we want to be intelligent and targeted in who is stopped. But that's not something new, that we don't just stop people randomly. We never did. So why should we start doing it randomly or unenlightened, if you will, or uninformed, just because we have a modern technology available? So I think that's the basic point. Law enforcement has always been doing this. So what you need to care about is the very specific instances where a risk may occur. Just saying that per definition profiling will lead to different human rights abuses is in my view much too broad.
Thank you. And if I saw well, Lotte wants to make a contribution, please.
Yes, well, I totally agree with also the person that asked the question, and I would like to link it to a part of the privacy discussion, because what we see there is that sometimes the concept of privacy is not seen in like all its glory, and sometimes it's really reduced to too much of an individual right. While it's also important to realize that when data is analyzed on the group level and made to or used to make inferences that might be about groups but might also be about individuals, that for sure the right to privacy is at stake, and also that it's sometimes too easily reduced to just data protection, while also things like autonomy or chilling effects should not be left off the table. So I think, especially when looking at this kind of stuff, it's really important to take into account also other aspects of the right to privacy.
Thank you, Lotte. There is a question that actually links to the topics of transparency that we have been discussing now. The idea of providing some transparency about the use of data from the private sector by the law enforcement would be appreciated, but how do you see it functioning in practice? We saw a similar initiative from the company's side in a form of publishing transparency reports. Would you propose something similar? And how could such an initiative truly empower individuals? So that would be the question. Christian, please.
Well, I'll just briefly state, I think whenever we have these discussions and we look on the law enforcement side, at the end of the day, if law enforcement uses this data, you will be made aware of it. That is your basic right. If we use it as evidence, it will be presented in court. It will be given to your defense counsel, and they will be able to challenge it, call counter witnesses, experts, etc. That's how the rule of law works. I think that is always important to keep in mind when you're talking about transparency on our side. For the regular police and the way the justice systems work in Europe, there is transparency to a large extent. And other than that, I don't recognize that there's been a right through history of always knowing when the police has your data. I think that's also reflected in the law enforcement directive, which obviously implements data protection standards. It sets a relatively high bar before data companies need to be informed.
Yeah, I could think as an example possibly what is happening in the anti-money laundering sector, where we have a lot of informal collaboration between banks and law enforcement authorities, maybe. But I see both Lotte and Plixavra. So Plixavra, please. We need to keep it.
A quick remark that indeed transparency when data are transferred from the private sector is quite difficult. I think that if law enforcement process your data, you will only know it when you're a suspect of specific crime, not anytime before. And if I take the PNR example, I don't know any of my friends when they used to take planes and travel, knowing that their data are actually being transferred to specialized authorities. So I do think citizens' awareness is very important right now. Thank you.
Thank you. I would like to ask the last question. What are your thoughts on the use of images scrapped from social media for facial recognition purposes? For example, the Clearview app. Is it always proportionate? Well, I think we can all agree it's not proportionate, but with anybody, we have like a couple of minutes. Theodore, please.
Yes, well, it all depends. It can be proportionate. There was an opinion of the Data Protection Authority on not on this issue, but on a related issue concerning tax purposes, that it needs to be proportionate. So if it is targeted, if it is in relation with a specific issue, there is no problem. If you do it massively and you do surveillance in a massive way, I think that there could be a huge issue with proportionality. It all depends.
So thank you very much. At this point, we need to conclude. There is one more question that we didn't manage to answer, but we can look at it afterwards. And the person who posed the question can always email the relevant panelists. At this stage, I would like to thank all four of you, first of all, for accepting my invitation, for taking all the time to prepare technically and scientifically for this panel. Thank you for the excellent preparation and for the discussions. And I would like to thank also the audience that we don't see, although we are used to seeing our audience. And I hope next year we can all be in Brussels to enjoy the feeling of CPD2. Thank you very much.
Thank you.
Thank you all. Thank you, Eleni.